All right, we all know that we live in a very high-tech world. It's a lot different than it used to be. I'm not complaining about it in any way, don't get me wrong, but it's brought its own problems along with it. This world of Twitter and Facebook, et cetera, Instagram, you name it. In Chicago, actually in Illinois, I should say, Facebook is settling a lawsuit that claimed that it violated privacy laws by using a facial recognition sort of technology, I guess you'd say. It's a facial recognition lawsuit that was brought, and Facebook agreed to pay in Illinois in this suit $550 million for violating people's privacy. And the thought immediately comes up, wait a minute, what about the rest of us on Facebook? What about those of us in Michigan and elsewhere? Let's find out from someone who would know, I think, emerging technology attorney at Varnum Law, Jeff Stefan, on the other end of our line. Jeff, good morning. Nice to have you with us.
Hey, good morning, Frank. Great to be here.
I just wish I was in Illinois right now.
Yeah, exactly.
Now, what is this facial recognition, first of all, and then we'll get into the lawsuit itself and who's going to see money and whether this might spread elsewhere. But what is this facial recognition technology Facebook's been using?
Sure thing. The case was based upon Facebook has a photo labeling service called Tag Suggestions, which uses facial recognition software basically to make facial templates of individuals' faces with uploaded photos with Facebook. And what they did is they used that software to suggest names of individuals in users' photos. And Illinois' law, it has a biometric privacy law that requires an individual's express permission before a company can collect and store what they call biometric information, and facial recognition certainly would qualify as biometric information.
See, I don't. I guess what I'm getting at is I don't understand the advantage to Facebook to store somebody's images.
Well, I think. Well, go ahead.
No, go ahead. I'm waiting.
Yeah.
You got to explain that to me because I don't get it.
Yeah. Facebook and a lot of the social media sites are really, what they really make their money off of is data in various ways, whether it's data to make the service better for users, which is a part of it, but the larger part of it is their philosophy is to collect as much data about individuals as possible, which can then be used for advertising and their partners, which is really where they gather a lot of their revenue from.
Yeah,
there's a saying, and it may not always be accurate, but if you're using a service and you're not paying for it, chances are you're actually the product itself, and not necessarily, and your data may be used in ways that you're not necessarily aware of.
All right. So now in Chicago or in Illinois, who's going to collect the $550 million? Is it every Facebook user who gets a share of that, or how does it work?
Yeah, so Illinois' law is unique in that it creates a private right of action. So there's various privacy laws around the country, and most of them, the jurisdiction for enforcement is actually with the state attorney general, which has some teeth in it, but it's not quite as powerful as giving individuals the right to assert a class action, and that was which was asserted in Illinois. So basically, any Illinois Facebook user that use the Tag Suggestion service would be eligible for some money. And the statute provides up to $5,000 per violation. So the plaintiffs actually initially sought much more than the $550 million that was ultimately settled. It was actually in the billions. But the settlement went to $550 million, which is still an enormous number. And I think each user is entitled to around $200.
That's it
in Illinois. Yes.
Oh, jeez.
When you factor in the amount of Facebook users within Illinois, so it's deterrent, I think, from a regulatory perspective for companies, and it certainly gets a lot of attention. But in terms of any sort of meaningful remuneration for Facebook users, that's not quite there. So I think. And that's generally how class actions tend to work.
Yeah.
It's unfortunately the lawyers tend to get paid the most in those types of scenarios.
Yeah, no, I understand, and that's just the way the system works. And if you don't like how that works, and become a lawyer, that's real simple. Go to school for 8 years and see how it all works out for you. Hey, but in Michigan, let's sort of transfer this over and apply the Facebook lesson here in Michigan. What can they do with the pictures here in tagging them online for people in Michigan? And is there a remedy that people might want to seek legally in Michigan, or are there no laws that really apply here?
Yeah, right now there's only about 3 states that have biometric privacy laws, like Illinois. And Illinois is actually the only one that allows for a private right of action. And Michigan is not one of those states. But I will say the U.S. as a whole is going through a sea change in terms of how legislatures and really courts are dealing with data privacy. In Europe, they have an overarching data privacy law. We don't have that yet in the U.S. There's been some federal proposals. I don't think realistically anything's going to get passed until the election is over, regardless of who ultimately is elected. But the states are seeking to fill the void. California has a very comprehensive privacy law that extends far beyond California companies and impacts many Michigan businesses. But again, that only applies to California residents. But already in 2020, we've seen over a dozen privacy laws proposed in the state legislature, and I expect to see many more as the sessions progress. And so I think that overall, from a Michigan business perspective, I think companies definitely need to start really investing some resources and thinking about how they handle personal information of individuals, whether it be facial recognition or just basic personal information like Social Security numbers, names, email addresses. And for consumers, the state attorney general always maintains jurisdiction for any sort of consumer rights violation. And even though some of this may not fit directly into privacy law, if this actions by a company are egregious enough, that's always a place to go. With Facebook's specific scenario, unfortunately, I don't think there's much of a chance of a remedy for a Michigan resident.
Well, I don't know whether you know, but I've been a frequent critic of our Attorney General here in Michigan, but this is one area where I wish she would become an advocate and very active on behalf of the people, and I think it would help a lot of folks out. So there you go, Dana Nessel. We got something we agree on. How's that?
Well, that's the thing about data privacy and regulation in this area. It really is a bipartisan issue in a lot of respects, there's not a lot happening at the federal level in terms of any sort of legislation lately, but this is one area that I think is sorely needed for several reasons, and it is mostly a bipartisan issue. Because from a compliance standpoint, the states are really feeling like they need to fill the void of a lack of a comprehensive federal privacy law. And I think that's overarching good in the sense that it's seeking to protect consumers. But from a business perspective, when you have multiple states with different requirements, the compliance costs and burdens can become pretty difficult. So I think that from a consumer standpoint and from a business standpoint, I think we all would eventually, benefit from a overarching federal law that addresses this.
All right, Jeff, appreciate the time. Thank you so much. Emerging technology attorney at Varnum Law, Jeff Stefan. Great to have you back on the show, my friend.
Thanks, Frank. Take care.